Now, here in Nigeria, the Supreme Court in Abuja has fixed Monday, January 15th, 2024, to hear the petition of Patrick Tonye-Cole, the governorship candidate of the All Progressives Congress (APC) in Rivers State in the 2023 general elections against the Independent National Electoral Commission (INEC), Governor Siminalayi Fubara, and the People's Democratic Party (PDP). Part of the prayers of Tonye-Cole is that the court should sack Fubara as governor for failing to resign as accountant general of the state after emerging as the candidate of PDP in the last election. Tonye-Cole has also argued that Fubara was not qualified to contest the last election, let alone be declared the winner of that poll. Now, joining us from Rivers State to speak on this issue is a legal practitioner and human rights activist, Henry Ekine. Welcome. It's good to have you with us on Arise News. All right.
Thank you. Good afternoon. It's my pleasure to be with you.
All right. Very good. You've seen what we've just read out. How would you assess the strength of the petition filed by Mr. Patrick Tonye-Cole? Does he have a watertight case at the Supreme Court at this rate?
Well, the fact that the matter is sub judice, at least before the Supreme Court, the extent to which the tribunal and then the Court of Appeal had considered and taken positions with respect to the grounds that Patrick Cole has actually raised before the tribunal and the Court of Appeal on his petition, one would say the issues ordinarily are extant in the provisions of the law, the Constitution and the Electoral Act, which ordinarily are the fundamental legal frameworks to regulate issues for election in this country. And the expectation is that every stakeholder in the electoral process is required to be bound by the provisions of the Constitution with respect to the requirements for qualification to fill the position of governor of a state. And then the Electoral Act being the fundamental signpost, if you like, to regulate the process and procedure of elections, how elections are to be conducted by the Independent National Electoral Commission, and then what will constitute regularity or irregularity, and then what would also constitute the grounds for petition by any dissatisfied candidate after an election. So all of these are actually provided extant. And to be able to review, like I said, rather the positions of the tribunal and then the Court of Appeal, being a bit careful with the matters before the Supreme Court, because the Supreme Court is only going to get into hearing where the counsel to both parties will argue their briefs. That is the appellant counsel to argue the appellant brief, and then the respondent's counsel to argue and adopt the respondent's brief. That extent, it's sub judice before the Supreme Court. So one would be very circumspect in getting to the merit as to what is right and what is wrong on the grounds for that appeal at the Supreme Court. But it's important to still be able to mention provisions of the Constitution with respect to elections. It is required that any candidate or any person who is going to be a candidate for an election, because there are two levels of elections, if you like. The primaries in the political parties could come by way of elections, whether it is direct, indirect, or by consensus. Then again, there are qualifications in the Constitution that even the political parties are required to observe in accepting those who will express interest to be candidates of those political parties. It's expected that political parties would, in their procedures and guidelines for conducting their primaries for the purpose of nominating candidates for elections into those positions created in the Constitution, they would comply with the provisions of the Constitution with respect to qualification. So if the Constitution has required that a public officer or someone holding a public office and is aspiring to become a candidate of a political party, that within a threshold of a period is got to resign from that position to be able to contest to run that election, then it's a constitutional provision. And then the political parties are required to observe those provisions of the Constitution as well. Then again, but of course, like I said, the merit, what the Supreme Court will look at is whether there was that compliance. So I would only to the extent that the Constitution and the Electoral Act are clear and every citizen can make reference to those provisions, then I think I can speak to that regard. Then you go again, to be qualified to run election to the office of the governor of a state, then you look at the provisions with respect to disqualification, because there are two aspects to it. Where you look at the provisions with respect to qualification to be a citizen of the Federal Republic of Nigeria by birth, and because there are other forms of citizenship of this country, pursuant to sections 25, 26, up to 28 of the Constitution that deals on citizenship. But the Constitution requires for qualification to be elected into the office of governor to be a citizen of the Federal Republic of Nigeria by birth. Then you have to be educated to a minimum of a school certificate, and then the interpretation of what that means is provided in the interpretation section of the Constitution. Then you have to attain a certain age, and then again, you have to be sponsored by a political party. Those are the qualifications. But then what's also very important is to look at the sections with respect to disqualification. And then that's where those other issues that form the ground would come. Then if you turn to the Electoral Act, how elections should be conducted in terms of compliance with the Constitution, the Electoral Act, and even the electoral guideline that would have been formulated by INEC pursuant to the powers vested on INEC as the electoral umpire in the Constitution. So these issues really, generally, whether it is the Tonye Cole's petition or any other petition, these are the issues that a dissatisfied candidate in an election will petition the tribunal to review the electoral process, the process of emergence of a particular candidate in that election after the Independent National Electoral Commission would have conducted an election. And then the issues would also arise in elections as to who has the competence to be able to raise these fundamental issues or to constitute the ground for petition. And then the tribunal earlier, of course, had looked at this, and the fact that that had been concluded, we'll be able to make reference to it, where they talked about the petition of Tonye Cole lacking in merit. And that, of course, led to his dissatisfaction, and he appealed to the Court of Appeal, where the Court of Appeal also upheld the position of the tribunal. But, of course, agreed with Tonye Cole to the fact that where one of the parties that the Constitution and the Electoral Act provided as competent parties to institute election petitions, where one withdraws, the other can continue. And in context, what I mean is the competent persons to file election petition against any declaration of INEC will be a person who was a candidate in the election himself, the political party that sponsored that candidate. So Patrick Tonye Cole, being a candidate in the election under the platform of the All Progressives Congress, clearly stood out to be one competent candidate. And then, of course, the political party that sponsored him, the All Progressives Congress. But at the tribunal stage, there was the issue as to whether the political party having withdrawn their interest in the petition, if the other person, that's the candidate alone, can continue with the petition and prosecute the petition to its conclusion. And that's, of course, would have been elementary, where we all know, even as lawyers, that where there are multiple claimants or plaintiffs in a suit or applicants, one can discontinue. The suit can be discontinued, withdrawn. One can withdraw his claims, and then the other, if he still has a claim, can pursue his claim. So that particular point or ground, the Court of Appeal agreed with Tonye Cole and disagreed with the tribunal that cannot be a position where anyone will contest. It was so clear. But the other grounds, the Court of Appeal agreed. So what's is important here is to wait the outcome of the decision of the Supreme Court, because tomorrow is hearing, like I explained earlier, the hearing of an appeal before an appellate court is where counsel to the parties, the appellant and the respondent, will argue, adopt and argue their written briefs, the appellant's brief and the respondent's brief. And then the court will reserve judgment or even give judgment that same day or any other day that the court prepares and is ready to deliver the judgment.
All right, Mr. Ekine, permit me to ask two questions. Number one has to be the fact that, do you think that the doctrine of stare decisis might actually play into this particular issue,
yes,
into this particular case, noting that there is a precedent when it comes to issues like this, especially the sticking point for Mr. Tonye Cole, which has to be the fact that some would say that it is pre-election matters. We saw this in play out time and time again when issues like this went to the Supreme Court. And secondly, do you think the impasse between Governor Similai Fubara and the Minister of the FCT, talking about Nyesom Wike, do you think it will give this particular judgment and this case a new dimension or a different dimension? Let's get to hear from you.
Yeah, thank you. The common law principle of stare decisis, simply expressed as let the judgment stay or stand, that forms the foundation of precedents, is adopted in the Nigerian legal system. So even the Nigeria courts hold on to that very sacred principle. The Supreme Court as well is bound by its own decisions. But the other lower courts, of course, apparently are bound by the decisions of the superior courts as the hierarchy of courts are established. Having said that, the Supreme Court, even recently, the judgments that the Supreme Court has just delivered within the week, that is the last week, Monday to about Friday, there are decisions with respect to pre-election matters and then issues with respect to, though not here, not in this particular context, issues with respect to membership of political parties, being internal affairs of political parties, issues relating to nomination, the process of emergence of a candidate from the political party primaries, whatever kind of primaries, whether it was direct, indirect, or by consensus. Then issues also related to qualification of candidates to run elections. That is the one that is also one of the grounds that Tonye Cole has raised. The Supreme Court has actually made some pronouncements with respect to these issues, some of which the court had held that they are clearly outside the jurisdiction of the courts, even outside the jurisdiction of the tribunal, let alone the appeal court and the Supreme Court, or any court in that regard. But I think, like I said, I won't go beyond this point. The Supreme Court will determine these issues, including that of qualification, when it delivers judgment on the appeal by Tonye Cole, because one of those grounds of Tonye Cole is the issue of non-qualification of Sir Siminalayi Fubara to contest in that election. Then whether the unnecessary and avoidable, because I would always maintain this position, the unnecessary and avoidable skirmish, or if you like, political crisis in Rivers State, which of course was orchestrated for some personal interests, and that everybody could see that clearly, whether that will influence the way the position of the Justice of the Supreme Court would go with respect to this appeal. I would say with respect that the Justices of the Supreme Court are believed to be incorruptible. They are believed to be justice that are objective in their consideration of matters before them. And they would not be unduly influenced by some extraneous considerations, including the crisis in Rivers State. I think the Chief Justice of Nigeria had at some point made a comment in this direction that Justice of the Supreme Court and other justices, judges of courts are guided only by the laws, the Constitution, the laws, and of course the facts and evidence before them, not extraneous matters.
Very good. Mr. Henry Ekine, we've had a very enlightening conversation with you. I'd like to thank you. Henry Ekine, legal practitioner, human rights activist. I'd like to thank you for your thoughts on this issue. It's good to have you with us.